Hello, everyone. This is Josh Robinson at Checkmate. Thank you, everyone, for dialing into our webinar this afternoon. It's 12:03 now. I'm going to give everyone a minute to get into the meeting space here, and we will get started in just a minute. Thanks again, everyone, for signing in, and I look forward to well, sharing as much good information as I can with you on the latest developments. All right, it looks like we have a pretty good group of people online so far. So I'm going to dive right in. So we have this webinar scheduled for an hour and a half. It is being recorded right now. And unlike the last couple of webinars, I don't have a particular presentation to go through today. I have instead a bit of updates that I want to go through, and I want to provide some background on what you can expect for Checkmate, from Checkmate based on the specific CARES Act situation that applies to you. And then also I want to go into some details around Checkmate's experience so far with the SBA loan process. And finally, we're going to spend most of our time on Q&A. I have a whole bunch of questions that have come in that I'm going to start off with, but while I'm presenting, there is a Q&A panel that you should be able to pull up, a little module here that you should be able to pull up to post questions. So anything that is on your mind that you have yet to send my way, or to someone at Checkmate, or anything that you might have that you want to make absolutely certain is addressed, please do feel free to start posting those questions. The more of your questions that we get here, I think the better off we will all be. While I'm going through this, there may be some questions that come up that seem to be specific to very specific and unique to an individual circumstance, and I just want to apologize in advance if I choose to kind of speed through an answer to a question. The intention would be that every question gets thorough consideration and a good response. But again, our time is limited here, so if I do end up doing something like that, I'm going to make a note of that question, and my goal would be to call whomever it was that posted such a question to talk through the answer directly sometime this afternoon. After this webinar, I have most of the rest of my afternoon set aside for doing some research on any questions that come up that I'm unsure about, and also getting back to some folks that have posted questions that if I get to them here on this webinar that I intend to follow through on. So with that all said, we're going to start off with just a little bit of a status update on where we're at right now. So it was a little bit over 2 weeks ago, maybe 2.5 weeks ago or so, that the Congress, maybe even 3.5 weeks ago at this point, that Congress passed the Families First Coronavirus Response Act, which came with the mandates for employers to be providing paid emergency sick leave and paid emergency family leave to employees who qualify for specific COVID-related situations. And then we had last Friday the CARES Act, the $2+ trillion CARES Act, which passed. And contained within the CARES Act, of course, was the $349 billion package for small business loans, which is all being managed through the SBA, which was an organization that was never designed to handle this sort of volume, and is now getting tangled up with the local banks. And I'm going to go into some detail here in a few minutes on what I mean by tangled up. I have some good experience, I think, that will be worthwhile to share. So we had the FFCRA, we had the CARES Act, both that passed. In addition to the, the payroll impacts, the CARES Act having the Paycheck Protection Program, and it also had within it a couple of provisions for companies that don't participate in the Paycheck Protection Program, one of which was a option for an employer who does not participate in the Paycheck Protection Program to defer the employer side of Social Security taxes accrued payroll by payroll for the remainder of the calendar year 2020. You have the option of deferring the employer side of the Social Security tax into 2021 and 2022. Basically, half of the total liability would be owed in one fell swoop on a given day in 2021, and then the other half would be owed on a given day in 2022. I forget the exact day off the top of my head, but that is in some ways equivalent to a zero interest loan that the government's granting, because it's money that you can keep in your possession rather than having to send it into the government. But it does mean that you will need to be prepared to pay all of that money upon the due date in 2021 or 2022 when that time comes around. Right now, we are actively working with Kronos and MasterTax, which is the company that we work with for our tax software, to make sure that we are creating the best, most efficient and systematic way to manage our customers who are deferring the payment of their Social Security taxes. My expectation is that we will have in place automation around this for our customers by the second full week in April, which will be for the period that includes the first full week in April as a pay period. There's also another tax provision that was in the CARES Act, which is available to companies that do not participate in the Paycheck Protection Program. And this other option is what's called the Employee Retention Tax Credit. And the Employee Retention Tax Credit is specifically for companies that do not take out a Paycheck Protection Program loan, who are shut down due to quarantine or state mandate, or also companies that can demonstrate a direct and significant loss of earnings that has to be greater than 50% of loss of earnings year over year from 2019 to 2020. If those situations apply, then you have the ability to take advantage of the Employee Retention Tax Credit. The Employee Retention Tax Credit operates much like the FFCRA tax credits do, where it is a credit on, in this case, on your Social Security taxes. And it is a refundable credit, which means that if you end up incurring more cost, if you have more credit that you should receive, then you have Social Security tax liability to begin with, then you will be able to receive an expedited refund from the IRS for this Employee Retention Tax Credit, or you'll be able to receive your money back when we file the quarterly tax return. The credit is for 50% of the pay that you issue to your employees while you are closed due to a COVID-related shutdown. Up to 50% of the pay that you pay your employees during that period of time is refundable to you in the form of this 941 tax credit. And again, if the 941 tax liability is not significant enough, then you can use a special process to get the money returned from the IRS, or you can get it returned when the quarterly filings happen. And this is to a maximum of $10,000 per employee for the calendar year 2020. Now, the $10,000, it escapes me off the top of my head whether the $10,000 is the maximum credit, or if the credit can be. I believe it's that the credit can be assessed on $10,000 of employee wages, which would mean that your maximum possible credit per employee for the calendar year 2020 would be 50% of $10,000 or $5,000. So conceivably, you can receive in the form of a credit from the IRS $5,000 to offset your payroll costs if you are shut down currently due to COVID-related reasons, but you still employ your employees and pay them via, normal payroll processing, but do not participate in the Paycheck Protection Program, then the employee retention tax credit is an opportunity for you. For both the employer Social Security tax deferral and the employee retention tax credit, I am not sure, and I'm going to make a quick note here, of the employer size limits on the employee retention credit, or the so basically I've had some questions from some of our customers that are bigger, that have more than 500 employees, about whether or not, or what our plan is to support the deferral of the Social Security taxes. And I am not aware off the top of my head, based on what I have read, that the ability to defer your Social Security taxes is limited to customers that have less than 500 employees. It may well be available to companies that have more than 500 employees, but this will be something that we're going to be, all of these questions that I'm mentioning to you that I don't have answers to right now, we are going to be actively updating on a new part of our website, which is our COVID resource page, which I'm going to show you all here in shortly, so that you all know where you can go to get some good information. So those are the two special tax provisions of the CARES Act that I wanted to spend a few minutes to describe, because that does change the equation a little bit for determining whether or not you're going to pursue the Paycheck Protection Program or take advantage of one of these other opportunities. It is something that you kind of need to do some analysis around to figure out. Again, the 50% tax credit on $10,000 of wages, assuming that, you're back up and running full time, full operation here come late spring or early summer, a 50% tax credit on those wages paid, you probably wouldn't be hitting that $10,000 limit by the time June rolls around. So that could, for some employers, be just as attractive, if not perhaps more so, than the Paycheck Protection Program loan. So with that said, I want to now dive into the Paycheck Protection Loan, because I think that is probably one of the biggest topics of concern for everyone on the call right now. As most of you are probably aware, that the banks supposedly are accepting applications for the Paycheck Protection Program loan today. Today being the first day that the applications supposedly have been able to be processed. And I will get into some details on what I mean when I'm using these, supposedly and whatnot. But the fact of the matter is, just to make everybody aware, again, we are all operating in a world right now that is so far from ideal. Quickly enacted federal legislation is always a bad idea, and this is an exact example of that kind of circumstance. Yesterday I sent out an e-blast to everyone, and I started that e-blast off with a little, a happier tone than normal, because I had seen the loan application, and it did feel like there were some movement happening at the SBA level that you don't see every day happening. Quick action happening at the federal government level. but that said, I'm going to change my tone here on this because I am extremely concerned, and I'll just lay it out for you a little bit why. We're being in the payroll business as we are. I'm connected with a number of trade associations that we're part of, and so whenever there's new legislation or new rules or new anything, we are in the loop on this stuff much sooner than the general public usually, and even other industry experts. And so last night there was a big correspondence going on in one of the groups I'm part of, because last night, finally, and I didn't even know this hadn't been done, but finally, last night, the Small Business Administration issued its final interim rule on how the PPP loan program is going to work. And here we are, at this point, having already figured out or using all of the resources that have been provided, done our best to figure out all of the details that we need to account for in determining the maximum loan amount that we could qualify for. And now we have the SBA issuing its final interim rule, which I wouldn't be saying it like this if the final interim rule was matched what we thought it was going to match. But in this case, the final interim rule has some language in it that again, it changes the equation for how you calculate your average monthly payroll cost. And the banks have already gone full speed ahead, and advised all of their customers to use a process, in determining your average monthly payroll cost that was, put out to everyone before last night. So again, what I'm trying to get at, everyone, is that this is a moving target. Nobody knows anything for sure right now, because everybody is operating under these things that we think we know. And given that as our reality, I believe that the best path forward is for us, when we are filling out our PPP loan application, when we are, getting all of the numbers from Checkmate, because I've got people who are actively pushing the new report out to everyone's account to help you determine what your total loan amount might be. The thing that I need for everybody to understand is that this is a moving target. And so I'm going to do two things. Firstly, right now, I'm going to describe to you what this report that we're pushing out into everybody's account includes for information. And then secondly, I'm going to dive into a detailed explanation of Checkmate's loan application experience so far and everything that I have done for Checkmate. So the report that we are preparing and pushing into everybody's account is called a PPP Disaster Loan Analysis Report. And as we push this into your account, you should be getting emails from your client account manager. And we're starting with everybody that made a special request for this report to begin with. Everybody who is on this call that absolutely needs our help, without question, in preparing this report for your loan application, please just send a quick email with CPP or PPP report in the subject line. Send a quick email to COVID-19@checkmatepayroll.com with PPP report in the subject line to make absolutely certain. If you send that email to us, then you will be on the short list of customers that are going to get our attention first after the initial group that we're rolling this out for right now. And the PPP loan analysis report, we are running the latest news from SBA indicates that the period of time that you should run your calculation on is the last 12 months. So we are setting this up in everyone's account to run from 4/1/19 to 3/31/20. However, the PPP loan application indicates that most employers will use the calendar year 2019. And, so this is where I think that it's important for the decision that you make on how you're going to determine your total payroll cost. You have to use a good faith effort based on, everything that you know, to use a reasonable method for calculating your average monthly payroll costs, and document the reason, document the, all of the rationale that you decided to use, so that once your loan is approved, if there's anything that comes up where anybody brings up the idea that, hey, you actually should have had a loan application or a loan amount that was lower than what you got, you'll at least have something that you can point to back up the decision that you made. And given all of the uncertainty happening here, and given the quickness with which all of this is being implemented, I have to imagine that by doing this, you're going to put yourself in the best possible circumstance. The report that we're preparing right now for all of our customers and actively introducing into your accounts has what we're calling the PPP gross total, which is your total gross pay for the period of time in question, or a max of 100,000. So it's capping out the gross total at 100,000 automatically. And then we are showing the employer costs for all health-related benefits. So that would be health insurance itself. It would also be employer contributions to HSAs, or employer contributions to medical FSAs, or employer contributions to HRAs. So we're putting all of that on your report. We're also putting on your report the employer contribution to 401k, Roth 401k, 403b, etc. And then we are also putting onto the report the employer's cost for state and local employment taxes. And then we are putting on the report additional details that may or may not need to be taken into consideration, which include the employee Social Security and Medicare tax amounts, and also include the employee federal and state income tax withholding amounts. So for every customer, this is the report that we are preparing and placing into your account for you to use for your PPP loan analysis. There is a very small fee that we're assessing for this. Depending on the complexity of the number of codes and whatnot, it's a minimum of a $10 fee, and in some cases it's a little bit higher than that. But in any case, we're preparing this, we're putting it in place for every customer, and if you send an email to COVID-19@checkmatepayroll.com, you will get on the short list of the customers that will get this first. And hopefully, by end of day today, if not over the weekend, it will be in place for you. The idea here is that you take this report and you simply sum up the columns that need to be summed up. You subtract from that the columns that need to be subtracted. And then you multiply, or rather, then you have your total annual payroll cost for the period of time. And you divide that by 12, which is your total average monthly payroll cost. And then you put that in your loan application and then multiply by 2.5. That is your total maximum PPP loan amount that you're applying for. And so, the reason, I'll just give you a quick explanation of why, my initial intention was for us to actually use this report to tell you what your total loan amount is. But prior to last night, the rule of the law itself said that the total amount of your payroll costs can't include the payroll taxes imposed or withheld for Social Security or Medicare tax, which inherently didn't make sense, at least not to me anyway. And there were numerous places that I was looking at offering guidance on how to calculate your amounts that omitted that detail. And then in the final rule that came through last night, the SBA determined that the Social Security and Medicare tax amounts in question are only those that were imposed or withheld from February 15th, 2020 to June 30th, 2020, which makes even less sense than disallowing the inclusion of those numbers at all to begin with. So again, what I decided that we would do is we would create this report to show you everything that you might need to take into account, so that you could, provide this report to your banker to back up the loan that you're asking for. And again, this is why we're not coming out and literally saying, based on this report, your total loan amount is X. So with that all said, again, I'm just going to summarize again what's on this report and what you need to consider in calculating your total annual payroll cost to determine your average monthly payroll cost. So the report itself and also the things that you need to consider are your total gross pay that were paid to any of your employees during the span of time that we're using, which would either be the calendar year 2019 or 4/1/2019 through 3/31/2020. So you pick which span of time that you're using, and then on this report, and in your analysis, you consider what is the total amount of the gross pay that we issued to any employee, maxing that out or capping that out at $100,000 if anybody received more than that. Then you also take into account the employer cost of health insurance, the employer cost of contributions to the HSA, to the medical FSA, to an HRA, anything related to the provision of health insurance to your employee that you as the employer incur a cost on that is not offset by monies that you withhold from an employee. You then add into that equation the total cost that you incur as an employer for retirement plan contributions, 401k, 403b, Roth. You then add into your total the total employer cost for state and local taxes. So that's SUTA taxes. That is the employer tax for, in some cases, in some states, employers incur a cost for instance, in Massachusetts, there's an EMAC tax, which is basically a supplement to the state funded health insurance program. So any state and local tax that you incur cost on as an employer that doesn't involve monies withheld from the employee gets added to your total cost calculation. And then, depending on which calculation you're going by, you would potentially subtract from all of those amounts apparently the Social Security and Medicare tax imposed and withheld from the employees for pay periods between 2/15/2020 and 6/30/2020. And then you would also subtract out the withheld federal income tax and state income tax amounts from that as well. So that is how you calculate your amounts. Now I'm going to give you an explanation of Checkmate's experience. Now we work with Enterprise Bank, which is a bank based out of Lowell. I think very highly of them. They do very good work for us. I'm more than happy to make a reference or make a referral to anyone who wants to get connected with someone over at Enterprise, if anybody needs or wants that. They are a bank that specializes in banking with businesses, and they are suffering the consequences of the same situation that your banker is, that everybody in the industry is. I was reading an article yesterday that indicated that the big banks, Wells Fargo, B of A, et cetera, are considering not even participating in this program at all because of the shoddy nature with which it's been cobbled together and things of that nature. So with all that said, the banks are doing their best. Enterprise Bank is doing their best to deal with, an uncertain environment themselves. Now, they sent me yesterday a few documents, one of which was the PPP loan application itself. And then they sent me a checklist document, which laid out all of the documents that they required. And what I did this morning is I made absolutely certain that I had absolutely every piece of information that was requested, put together in the order in which it was laid out in the checklist. And so I'm just going to go through and describe to you what it was that I had to provide over at Enterprise. So my whole idea, my whole intention here was to make sure that what I provide is so thorough and complete that nobody will have any questions. So what I did is I provided them the following. One was the completed Payroll Protection Program application, which is a 4-page document. The document itself that was created by the U.S. Treasury, makes it appear as if it's an electronic document, a PDF that is designed to work electronically, which it does work in some cases. But I did realize that, in the section where it says to list all owners, when I typed in my social and my home address, it was running off the field. So what I did is I typed in as much information on the form as I could, and then I left blank anything that didn't display nicely when I entered it in, and I printed off the form, and I hand wrote the information in the areas that were too small for the typed info to display, so that I could make certain that whomever reads this document sees exactly what they need to see, and we don't have any cutoff details. So I had to write in my own social and my own home address in the listing of owners. Then in the rest of the application with the check boxes marking yes or no and the initialing, I typed in my initials and I marked the check boxes yes or no on the electronic form. And then on page 2, I marked all my initials by typing them. And then I printed the form, signed the form, and made that the first document in my stack of documents for the bank, which I compiled all into one PDF file. So the first document in my one PDF file is the 4-page PPP loan application. The next document in my file is my articles of incorporation. This was the second item in the checklist provided to me by Enterprise Bank. So it's the second item in my file that I'm sending them with all of my info. The third document is the bylaws for my company. Again, don't ask me why, but the bylaws were document number 3. The fourth document was a copy of driver's license for all 20% or greater owners of the company. In my case, that's just me. So a copy of my driver's license was document number 4. Document number 5 was a copy of the 2019-940 for Checkmate, which is a 2-pager. The next 4 documents are what I'll call document 6, which is a copy of the 941 for every quarter of 2019. The 8th document, I think it's 8 that I'm on, I don't know, it wasn't asked for, but I provided it anyway. It was a copy of the W-3 wage transmittal form for Checkmate for 2019. The next document in my file is the PPP loan analysis report from the Checkmate system. The banks want a report from your payroll system that can be used to back up all of the other information, or at least can be used to compare against all of the other information that you've provided. It's not, there is going to be no clean tie out between, you know, the amount that I'm requesting in my loan app and the PPP loan analysis report in my filed quarterly tax returns. However, they will be able to use your payroll report, you know, to at least, you know, do their due diligence, and perhaps compel them to ask questions if there are glaring discrepancies. The next item in my file was a letter, which I simply wrote to whom it may concern, but this is a letter attesting that all employees that I employ in question live in the United States. So my letter simply says, to whom it may concern, in support of Checkmate Payroll Services and its application for a loan under the Paycheck Protection Program. This letter certifies that all employees of Checkmate Payroll Services paid in 2019 and year-to-date in 2020 currently live and reside in the United States. The next documents in the final documents in my package that I sent to the bank is the 2019 profit and loss report for Checkmate. So that is everything that I sent to Enterprise Bank this morning, with the expectation that at the very least they now have everything from me to process my loan. And given all of the information I provided, if there's anything that is glaringly questionable, the banker at Enterprise, you know, will call it into question with me. However, one of the things that I want to mention here, based on everything that I've read, is that I do believe that your bank, unlike most situations where the bank actually has a legal responsibility to make sure that all of the details associated with the loan application that they're processing for a customer are accurate and correct and reflect reality. I believe that the onus of that responsibility is actually going to be passed from the bank to you. And your, you know, through the PPP loan application, you're basically taking the risk of you know, potentially being non-compliant if you were not using, you know, a well-documented approach to how you're running your calculations and whatnot. I don't think that the onus is going to be, I don't think that they're going to hold the banks responsible for determining whether or not you actually truly qualified for that $350,000 that you applied for, or if you should have only got $150,000, as long as all of the documents that you provide seem to be at least somewhat aligned with, you know, a $350,000 loan amount and not a reflection of something that should have been a lot lower. But I know that this is one of the biggest hangups that the banks are having right now, because they're being, you know, the expectation has been thrust upon them, both at the federal level and now by the public, that they're going to be processing these loans so quickly, and that funds are going to be available, you know, same day as the loan application is approved, which is just crazy. So I hope this part of the presentation was helpful to folks as far as what you need to have together to provide it to your lender. And even if it hasn't been asked for yet right now, I would highly recommend getting it all together just as I described, because the more you can put yourself in a position where you hand off in one fell swoop everything that is needed, that doesn't compel, you know, numerous extra questions, the better off you are going to be. I did verify in my research last night that the PPP loan program, and of course, you know, it's kind of a no-brainer, I think, but maybe not. But it is a first-come, first-served program. So $350 billion. Whoever's loan applications get processed first get their money. And who knows what's going to come next. I'll take this opportunity to emphasize to everybody, please, please, please reach out to your legislators, reach out to your senator, reach out to your congressperson. express your frustration, express your concern. There's only one possible way. You know, if this ends up being a situation where the $350 billion gets drained in a heartbeat, you know, we need to be screaming bloody murder about the fact that, you know, that this is not playing out in the way that a rescue package would play out. And that's what this is. I hope that everybody understands this is not a stimulus package. They call it that, but this is not. This is a survival package. This is a you know, this country's economy is going to be, you know, in the, you know, in the toilet for years if we don't, you know, have this in place. And if all of this money gets eaten up so quickly, and you all and I, you know, don't get the full loan amount that we are entitled to here, you know, we need to be barking loudly. We need to be, you know, reaching out. So please take the time, because there's only one way that we can possibly, you know, hope to affect change right now. And I think that is reaching out to your legislators in the governor's office and things of that nature. With all that said, what I want to do now is just briefly speak about what is already in play here with Checkmate and FFCRA, and because I already mentioned, you know, about the deferral of the employer tax for Social Security and the employee retention credit, which we will have more information for folks as soon as we have that in hand next week about exactly how we're going to handle all of these details. The FFCRA credits, for many of our customers, most of our customers that use the time and labor management system, by now we have created your new time off categories, and we are actively putting in place all of the earnings codes for all of our customers to pay out on those time off categories. Right now, I am still working with Kronos and MasterTax to figure out the final details on how the exact the tax credit processing to offset the emergency sick leave cost that is incurred happening in the same pay period. I am still figuring out the fine-tuning the details with Kronos and MasterTax on exactly how that's going to work, and I will have more news for everybody as soon as I know. You know, sometime early next week is my goal. But the fact of the matter is that the FFCRA time off categories for emergency sick leave employee and emergency sick leave family and EFMLA have been put in place and should be in your account for most of our TLM customers. You should be receiving emails from our team as those are put in place. If you have not received such an email yet, it is very likely because you know, we're just putting the finishing touches on things for your account, but you will be able to take any time that is current on timesheets currently, 4/1, 4/2, and today, and then into the future. You will be able to take those hours and apply them to the proper time off categories as soon as you hear from us, letting you know that those time off categories are there and ready for you to use. And then once we get into next week's payroll, again, my goal is to have an update off to everybody Monday on how next week's pay dates are going to be handled. If the tax credit itself will actually be flowing next week when the costs are incurred, or is that going to represent a week in which the tax credit processing won't be able to happen for one reason or another. I'm going to, you know, let everybody know as soon as I can on Monday morning about the FFCRA tax credits. So with that said, we're going to dive into questions and answers. We've got 45 minutes left in our time. I'm going to start off with some questions and answers that I have on my end. I'm going to now stop my video here so I can show you my screen. I do apologize. These FAQs are not formatted nicely. They're really just, I have been All right. Okay, perfect. And okay. Oh, well, that's unfortunate. Yeah, FYI, everyone, stay tuned. We're going to be finding a new app to use for webinars, not Zoom. Okay. So let's see. I'm going to go through a couple of FAQs here that have come through on the, and then I'm going to show you the COVID webpage, and then I'll show you the COVID webpage at the end. Okay, so first question is, are we tracking anything regarding COVID legislation applicability specifically to household employers? And this is one I'm going to be getting up on our FAQs page on the website. Originally, the FFCRA itself does not exempt household employers from the need to comply with the FFCRA. And so for all intents and purposes, household employers need to be prepared and are obligated to pay out COVID emergency sick pay and emergency FMLA to their household employees when they have COVID-related reasons to not work. That said, I also, in all of my research, I discovered that the CARES Act itself explicitly excludes household employers because household employers are not quote unquote businesses. So the CARES Act specifically excludes household employers, but the FFCRA, it does not exempt household employers at all. And again, just to put that in other words, the FFCRA imposes the mandate to provide emergency paid sick leave and emergency family leave to employees, and that applies to household employers. The CARES Act, which is where the Paycheck Protection Program and other beneficial programs for employers live, does not apply to household employers. If an employer wants to pay out emergency paid leave out of their own pocket as part of a furlough, will the timing of the pay date versus the date of the furlough letter matter when it comes to filing unemployment? And this is a very good point of clarification, because in the webinar that I gave on Wednesday, I actually spoke about something that a customer that had shared with me when I was talking with them in regard to the idea that if you are shut down due to a state mandate, that is the equivalent of a quarantine, and therefore employees would be able to use emergency paid sick leave during the first 2 weeks of a furlough, if that furlough were to happen, say 4/1 and afterwards. And in fact, no, that is not true. I did further research after the webinar, and I've learned my lesson here. Do your research before you, share details, that you learn in changing times like these. There's so much uncertainty. But the fact of the matter is, that the clients will not be able to, in this case, in the context of this question, the client will not be able to avoid the need to comply with the FFCRA for any employee who earns wages from when the nanny is needed again in this case, or when your employee is needed again until 12/31/2020. Again, what that means, what I'm saying, the question was, if the employer wants to pay out emergency paid sick leave out of their own pocket as part of a furlough, will the timing of the pay date versus the date of the furlough letter matter? And the answer to the question is that any amount of pay that you offer to an employee above and beyond and outside the parameters of the emergency paid sick leave or EFMLA programs are at the very least going to be extremely, extremely complicated to work out the details of how your policies will be able to be meshed into this requirement and demonstrate your compliance. But in many ways, it would be in your best interest to think about this as it doesn't matter what you do otherwise. Follow the letter of the rule for emergency paid sick leave and EFMLA. And the letter of the rule for emergency paid sick leave and EFMLA has nothing to do with furloughs, nothing to do with layoffs. It has everything to do with whether or not the employee is not capable of performing their core function. If the employee, because if you try to do this and then it becomes apparent that you, despite what you did, you still have to comply, then you're simply going to be on the hook for, giving the employee their 80 hours of emergency paid sick leave once your furlough is over. Even after you've given them, 2 weeks of extra paid time off that you did in lieu of a furlough, because a furlough is not a legitimate COVID-related reason to pay your employee for not working. The only legitimate reason for COVID-related emergency sick or emergency paid family leave to apply are for those reasons that are specified in the FFCRA, which, to summarize, are if the employee has COVID-19 or is self-quarantining or mandatorily quarantining because of a fear that they have COVID-19, or if the employee cannot perform their core duties because they are home caring for somebody who has COVID-19, or if they cannot perform their core duties because they have to take care of a child whose school is closed due to COVID-19. Those are the only reasons why you need to pay any employee under emergency paid sick leave or emergency paid family leave for FFCRA purposes. And so my suggestion is that you not try to, fatten that up by, adding something on top of it. You would create something that would live in isolation separately from it. That would be some sort of added benefit. But if we tangle up anything else within these parameters of what's in the FFCRA, it's just going to set you up for ginormous complications. I suppose if you're looking for a reason to employ more HR people, that would be a justification for it. All right, so. Will an employer be relieved of any possible FFCRA CARES Act obligation if they furlough before April 1? Would it have to be a termination or permanent layoff to relieve them of any possible future obligation? And again, just to reiterate, the FFCRA has nothing to do with situations where the employer needs to furlough or lay off for non-COVID related reasons. So, if the reason why you need to do a furlough or a layoff in the context of this household employer, the household employer was no longer working at their office, and therefore she was home and could take care of her kid, so she didn't need her nanny to work anymore. That is not a COVID-related reason. That is a reason your position is no longer necessary. That is the equivalent of a layoff or a furlough, but not a COVID-related reason. These things are mutually exclusive. The need to lay off and furlough versus FFCRA. They are mutually exclusive. Next is a question in regard to the Paycheck Protection Program. I'm curious as to whether you have to prove hardship in order to qualify and what those requirements are. And you don't have to prove hardship for the PPP. And this is why it is so important to get your loan application in as soon as humanly possible, is because you do not have to prove hardship. You simply have to attest to hardship by acknowledging that hardship exists. It's one of the things that you have to acknowledge on page 2 of the application. It says that certification. So I had to initial a statement that says current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. So again, any business owner, could make that claim right now, because nobody knows what tomorrow is going to bring or next week is going to bring, and COVID-19 has affected everybody at this point. So again, you don't have to prove hardship. All you have to do is initial that section of the application. So then there's also a question, I'd also like to thoroughly understand what needs to be done or the qualifications to have the loan forgiven. And that's a very good question as well. The loan forgiveness requirements are going to need to be done. Basically, you're going to need to work this through your lender, and they are going to dictate what is required to be provided by you for them to determine how much of the loan to forgive. The finer details of the exact amounts that could be forgiven versus the amounts that can't be forgiven based on context, there is no clarity right now on that exactly, but I will explain what I know. There's two parameters that will determine the forgivable nature of your PPP loan. One is going to be whether or not you employ, as of 6/30/2020, the same number of FTEs that you used in determining your average monthly payroll cost as represented on your PPP loan application, or not. And the second parameter to determine whether or not your loan will be forgiven is going to be the approximate wage levels that all of your employees are being paid at as of 6/30/2020 versus those wage levels that were used in the determination of the total loan amount that you qualify for. In the context of the wage thresholds, the wage levels, the loan will be forgiven as long as your wage thresholds or wage levels as of 6/30/2020 are not less than 75% of what they were during the period in which you covered or used to determine what your average monthly payroll costs were. And for the employee count, it's an FTE count. Basically, so on your loan application, when you enter the number of jobs in the top right, that should be an FTE calculation. It's not the number of W-2s you issued in 2019. It's literally the number of full-time employees. So in my case, we had 21 W-2s last year, but my number in the top right of my loan form is 17 because there were 4 people that only worked a fraction of the year, and adding them up as fractional people added up to, like, I want to say like 1.71 individuals on top of 16. No, 1.71 on top of 15. So my number on my application is 17. Now, my understanding is there's specific details that I read about that stipulate, the forgivable amount is only going to decrease proportionally based on the specific scenarios that apply to your business. So, for instance, if your wage thresholds or your wage levels decreased by 40%, so you're paying 60% of the wages that you were paying, it's not to say that 100% of your loan won't be forgiven. It's only part of the loan that won't be forgiven because of the fact that you weren't, that you had numbers that came in under the level set in the legislation. For the FTE count piece, there is no information around how the change of your FTE count will affect the forgivable nature, which implies that any difference, any number of FTEs lower than what you used when you submitted this form will potentially affect the forgivable nature of your loan amount. So lacking other information, what I speculated about was that, okay, so if my number on my PPP loan form is 17 and I end up having 16 come 6/30, then I would expect that 16 divided by 17 times my principal amount represents the amount of my loan that won't be forgiven. But I don't know for a fact, and the idea of applying logic to any of this seems silly at this point. So more news on that when I know more. But again, I do know that if you have less than 75% of your total wages still being paid, then 100% of your loan will not be forgiven. And right now, I do believe that if you have any decrease in your FTE count, then some of your loan will not be forgiven. Yes, and then the additional question is in regard to the span of time for the use of the loan. So I want you guys to understand that to calculate your principal amount, you have to calculate your average monthly payroll cost, and that has nothing to do with the time frame in which you must use the loan money. The time frame in which you must use the loan money is between when you get it and June 30th, 2020. If you do not spend that money by June 30th, 2020, it will not be forgivable. It will be a loan that you will have to pay back. Now, the final rule that was issued by the SBA last night, which again still hasn't been published, but was issued by the SBA last night, indicates that the percentage rate for the loan is not going to be 0.5% like we were told earlier, but it's going to be 1%. So any amount of the loan that is not forgiven because wages were not paid or it was not used to pay wages by 6/30/2020 or for whatever other reason is going to be converted into a 2-year loan at a 1% interest rate, and the first 6 months of payback is deferred. So the soonest that you would be on the hook for paying back the loan amount will be 6 months after you take the loan. Okay, so we are at 1:05, so I'm going to keep going, but I'm going to go to the questions that are being asked in the webinar here in a moment. We also have an employee who's full-time, had him on schedule, but he chose to self-quarantine. We have work for him though, but he is choosing to not be on schedule. He was not told to self-quarantine at home by any authority. He does not have any children and is not caring for anyone with COVID-19. He filed for unemployment. This is an interesting circumstance, and this is not the first time that I've heard this, so I want to offer some suggestions here. If any of your employees, rather than coming to you to have a conversation about their situation, if any of your employees simply go to Employment Security and file an unemployment claim without actually having any conversation with you about the termination of their employment or their furlough or anything like that, from my perspective, if that was my person, I would consider that to be job abandonment and the equivalent of quitting. And therefore, when Employment Security sent me the paperwork, I would report back accordingly. I have heard from a number of customers that out of the blue, they just get a notice from Employment Security about this person, and they would have paid him COVID sick pay if that person had, gone to them and let them know their situation. In this context, the question is, how should this have worked? In this case, the employee, the wording of FFCRA is vague enough that it obligates you for the purposes of the employee's use of emergency paid sick leave. It kind of obligates you to, you can ask the employee to provide a note from their doctor. You can put those, make those requests, but you're kind of obligated to take the employee's word for it if they themselves are saying that they're self-quarantining, because the condition that requires your compliance is whether or not the employee has COVID-19 themselves or is quarantining, self-quarantining or mandatorily quarantining due to a concern that they might have COVID-19. But if this person went and filed an unemployment claim, then you're off the hook. You don't have to pay him for COVID sick time. And in fact, I don't believe that this individual technically would qualify for unemployment related to COVID either. I believe that this person quit. And should come back and work for you, which would then obligate you to pay them their emergency sick leave. So you might choose in this context to kind of, just let it ride, because at the end of the day, if employment security determines that, he's entitled to a benefit, that's between the employee and employment security. And none of these COVID-related unemployment claims are going to be chargeable against your account as an employer. Okay, so I'm not sure how to process payroll. The payroll I have this week, I have 2 employees working about 9 hours and 2 employees staying home. If I apply for the loan, am I to pay all employees full wages at this time? If they are collecting unemployment, will I still qualify for reimbursement? Good questions. So in the context of these questions, again, we need to talk about what I said before. If the reason why the employees are staying home is because they do not have a job to perform, then there's nothing here related to COVID sick pay. And therefore, this question is in regard to paying people who are staying home theoretically, on furlough because there is not work for them to do. The idea here is if you don't have work for them to do, it's a very dangerous thing to look at this from the perspective of, okay, while I'm biding my time and waiting for the loan, I'm in essence going to, draw from, cash reserves, or perhaps, as an owner, you lend money to the company to cover your payroll costs while you're waiting for your loan. My suggestion would be, if you don't have work to be performed by your employees, you let them go get unemployment, but put it as a temporary furlough, and create the expectation that as soon as you have work for them to do again, they are going to be, invited to come back in, and you're expecting that they will be there, to get started working again. And if you do it that way, then you won't be, draining company funds to pay people who are not working, but they will still be able to get weekly benefits from employment security. And then once you have that cash in hand, then you can bring them back on board. And as long as you bring yourself back up to the staffing level that was used in the analysis determining your annual or average monthly cost of payroll by 6/30/2020, then you will be in compliance with the staffing level requirements that will determine the forgivable nature of your loan. So you could make this happen such that you set everybody's hire date to 6/30/2020, and by simply doing that, then you will be in compliance. Actually, it would probably be safer to make it so that their pay date happens on or about 6/30/2020. But then you would be able to prove compliance with the requirement to maintain your staffing level, even though you had many weeks in which nobody was employed at all. I hope that explains the rules around the situation related to that question. Okay, so I have forms from unemployment that need to be answered. I tried to set up an online account, but I do not have a registration code. I'm not getting answers from them by email. Yeah, unfortunately, guys, employment security is completely, absolutely swamped right now. I know that you as an employer have an obligation. I think that at this point you're probably going to have to use, I certainly hope they're still allowing you to use a paper-based process. I think you're going to have to use a paper-based process. The questionnaire that they send back to you, you're going to have to fill it out manually and send it back to them. If this was a situation where, again, where the employee did not deserve unemployment for COVID-related reasons, I will leave it to you to determine whether or not you're going to challenge that by saying that you actually, terminated that person for cause or something, because, if you did have somebody leave the organization and there's any risk of any type of discrimination lawsuit or anything like that, you're getting in the way of between the employee and an unemployment claim could be one of the things that could motivate them to pursue action against you as the employer. So can you tell me if you're preparing for the tax credit program regarding recent legislation? Yes. We are preparing for the tax credit program. As I said earlier, my intention is to make it so that the tax credits are received in the same pay period in which the cost is incurred. More news on that on Monday. I promise there will be detailed news for everyone on Monday about exactly how we're handling tax credit processing. So that said, I'm going to go dive into Q&A that's out here. And we're gonna, I'm just gonna go through as many of these as I can in the next 15 minutes. There's 22 questions. Following this call, I am gonna touch base with a couple of my team members and make sure that everybody gets the answers that you need to these questions if I don't get to them. I know that if I try to do this myself, there's going to be some folks that I don't get to. So I'm going to have a couple of people help me. So you can rest assured that your questions will be answered. Okay. So under the exclusion of the loan calculator form, is the 100,000 plus payroll completely excluded or just the payroll over 100,000? Very good question. In the final rule from the SBA that I read last night, they actually included a couple of examples of how to do that calculation. And their examples, literally said, first, sum up all compensation, then sum up all additional employer costs, including health insurance, 401k, et cetera, then subtract compensation earned over 100,000. Based on the verbiage there, that demonstrates to me that the cap at 100,000 is only on the compensation paid to such individuals and does not take into account the amounts paid by the employer for health insurance or 401k, et cetera, which means that the amounts that you pay for health insurance, retirement, state taxes for individuals making over 100,000 a year can be included in the total amount that you determine, that you use to determine your average monthly payroll cost. I included it in mine, and based on everything I know, I would suggest that you do the same. Could you let us know when the average payroll report will be available? We were applying for the PPP. Yes, we're actively pushing this in to every customer's account. We're actually going to do a mass addition of the report into every customer that doesn't already have it this afternoon, probably late afternoon. That said, for every customer, what's going to have to happen here is once we push the report into your account, we then need to make sure that all of the columns for each of your items, the employer health insurance costs, et cetera, are in your report, because the columns from one customer's version of the report are not the same for another customer necessarily. So this means that there is going to have to be individual attention provided by one of my team to make sure that your report is exactly what you need, which is why I'm saying if you are particularly concerned and really need that report ASAP, do please send that email to COVID-19@checkmatepayroll.com, and your account will get the unique attention that you need to have so that you can get that report ASAP, and hopefully, no later than Monday morning for you to make your loan application. Every customer is going to get the form added, but because we need to do individual attention for every customer to make sure that the report that's in your account is what you need it to be. And because, there's only so many of us here, in order to guarantee that you get it quickly, send an email to that COVID-19@checkmatepayroll.com email address with PPP application or PPP form in your subject line, and you will be at the top of the list to get it ASAP. Did your bank offer a PPP application before today, and were you able to submit already today? Yes. So my bank sent me the PPP application and all of the checklist and whatnot yesterday. It was about maybe around 1 o'clock yesterday afternoon, and I submitted my application this morning. After scrambling around and getting everything together in one PDF file, I submitted my application this morning. I do not know anything beyond the fact that I submitted everything that they need. Ours has not provided one yet. However, we've worked off the SBA sample app. Yeah. So the U.S. Treasury has a loan application form, and I believe that the SBA sample application form is the same one. And that is actually what I ultimately used for my loan application. That is what was sent to us yesterday by the bank to use. I know that there was a revision to it that was made last night with the SBA final rule, but my bank has not suggested that they're even considering that. They in fact said that the original application was completely sufficient. So next, the exemption for paid sick leave for employers with less than 50. Good. Looks like it only applies when employees' leave is related to school closings or loss of child care. If an employee is advised by a doctor to self-isolate, the employer would still be required to pay the sick leave. Is my understanding correct? So two things there. So first, the point of clarification. There is no exemption from FFCRA inherently for any employer unless you have more than 500 employees. So every employer inherently by default must comply with FFCRA. The ability to become exempt from needing to comply with the FFCRA, yes, as far as I am aware, based on the language that I've read, you can request an exemption to not have to comply with the EFMLA portion of the FFCRA, which is the portion that is exclusively related to the additional 10 weeks of pay for the inability to perform your core function due to the fact that you have a child at home whose school is closed due to COVID. You do have to, though, the DOL just issued guidance. I'd suggest anybody, who's interested in reading about this, and I will cover this in a webinar next week. But the DOL did issue guidance, I think yesterday, on what makes or what you would need to have in place, what the conditions would need to be in order for you to request an exemption from FFCRA. However, although they issued that guidance, they did not follow up and actually provide guidance on how one requests the exemption. So I am going to cover this in a webinar next week. The exemption option is supposed to be there. It is supposed to be available for for employers that employ less than 50 employees, but it is not well defined, and there is no formal process to use for it right now. The guidance that I did read was if you are intending to pursue that right now, you can look at those conditions that the DOL specified. You can call yourself in compliance with those conditions and call yourself exempt, and then wait for word on when the what the process will be to formally actually get approved for that exemption. And while we're on that topic, I want everybody to keep in mind that yes, the legislation that we're talking about, FFCRA, came into effect on 4/1. However, the DOL did issue a 30-day grace period for employers to become compliant. So any quote unquote violations of FFCRA that happen between now and 5/1, you will not incur any penalties from FFCRA on. So this gives us a little bit of a window to figure this stuff out, which again is why I will be having a webinar next week that will cover some of the details on requesting the exemption. I just need to do some research to figure things out so that I can offer good guidance. So if someone owns multiple small companies, all with their own tax ID number, can each business be able to apply for their own PPP or SBA loans? So yeah, there's literally on the PPP loan application. Let me pull up the page here. There's So there's basically a question on here that asks if you have, if you are in this, is the business or any owner an owner of any other business or have common management with any other business? If yes, attach a listing of all affiliates and describe the relationship as Addendum A. And the reason for this is that my understanding, there are affiliation rules that are being used here that are also tied to the affiliation rules that are used for employers in regard to compliance with FLSA. You know, if you are considered to be an affiliated employer for FLSA purposes, you would be considered an affiliated employer, I believe, for the purposes of the Paycheck Protection Program. An individual can only have, or there can only be one Paycheck Protection Program loan issued per owner, I believe, is how it works. Now, other SBA loans, if you have other EINs that you own, I do believe that you can get other SBA loans for other EINs, whereas the Paycheck Protection Program does seem to be intended for a single employer, which would mean that it's probably likely that the numbers you would use for the Paycheck Protection Program loan app would be summing all of the numbers for all of the affiliated employers if you can't do one of these loans per employer. Okay, so then we feel your pain. Thank you. Well, I appreciate. Thank you, Mandy. You know, yeah, this is crazy times for us. Again, we are doing everything we can, you know, to be here as a resource for you. You know, we are struggling just like you are, but at the end of the day, you know, this is one of the reasons why you outsource your payroll. You know, because you know you need experts like us to play this role for you when we need to play this role. I do look forward to when we get everything, you know, back in a stable kind of situation, so I can take a vacation. But do not worry. I appreciate the thank you there. But you know, we are here to help, and everyone on our team, you know, sees it as our mission. You know, to be a life raft here, you know, for you guys while we're struggling through this together. Okay, so you mentioned something earlier about 10,000 for deferring Social Security. Please, can you explain what you meant about the 10,000? Yes. So what I meant about the 10,000 is that the rule for the provision that allows an employer to defer their employer Social Security tax liability, or rather, I'm sorry, the employee retention tax credit is what we're talking about. The employee retention tax credit allows an employer who is shut down due to COVID, but is still paying their employees who are now on furlough via payroll. It allows you to receive, in the form of a 941 tax credit, 50% of the total compensation that you pay, period, maxing out at $10,000 for the calendar year 2020. Again, I'll say that again. You are entitled to a tax credit equal to 50% of the total compensation that you pay to an employee throughout the entirety of the rest of 2020, maxing out at $10,000. And again, the question that I have to figure out the answer to is whether the cap is on employee compensation, capping at $10,000, and then your tax credit is 50% of that, so $5,000, or is the cap a cap on a maximum per employee tax credit of $10,000? I believe it's $5,000 and not $10,000, but I need to verify that. But yes, that is the idea with the employee retention tax credit. Your business must be completely shut down, or you must have already seen at least a 50% drop in revenues, and then B, sorry, I just lost my train of thought. Yeah, I just lost my train of thought. Sorry, guys. But I think I explained that. For the tax credit, you must be shut down, and then the employee must be still on payroll on furlough. Otherwise, there won't be anything for the IRS to give you a tax credit on. Okay, can you repeat the email address we need to send? Yes, it is COVID-19. And yeah, that's a good suggestion. I'll put it in the chat. COVID-19. Currently no technical difficulties, but it's COVID-19 at checkmatepayroll.com. Do employers use 1099s in their calculations for the average monthly payroll cost? No, they aren't. 1099s are explicitly and directly excluded because 1099s can get their own PPP loan. Can you include the cost of health insurance reimbursement in total payroll? Yes. It's a cost to the employer and it's taxable to the employee. Yes, you can. It's compensation. It's just standard W-2 income. Enterprise accepted the SBA sample app, or did they provide an application of their own already? They accepted the SBA sample app, or at least I believe it was the SBA sample app. It was the loan app they sent me yesterday. It looked identical to the one that was on the U.S. Treasury website, which was the SBA sample app. How did an employer go about reducing its federal employment tax deposits to fund qualified leave wages before receiving the credits? So basically, the way I'm intending for this to work, and again, I still need to verify some details with the software vendors that we work with, but is that basically we process your payroll for a given pay period, and in that payroll there is emergency paid sick leave being paid. Let's just say to one employee. One employee is getting 10 hours of emergency paid sick leave. And let's just say that that employee's hourly rate is $20 an hour. So this employee is getting $200 of emergency paid sick leave in their paycheck. And let's just say that the total payroll for this account has a total payroll cost, gross cost of $10,000. And let's just say a 941 tax liability of $1,000. We have a $200 tax credit that is owed by the IRS back to you for that pay period due to the $200 of emergency sick leave that's being paid to that employee. So the way I'm intending to make it work, and again, I still have to work with the software vendors to make it play out like this, but the way I'm intending to make it work is that in the same pay period in which that $200 cost is incurred for emergency paid sick leave, that the 941 tax liability that is calculated in that payroll and that generates the ACH transaction to pull the tax money from your bank account is reduced dollar for dollar by the amount that is spent on the creditable expense. That is how I'm intending for this to work in the grand scheme. I don't know yet right now if all of the code configuration and development work that needs to be done on the software vendor side will be in place next week to make it work that fluidly. And so on Monday, I'm going to be sending a communication to everyone that will explain, based on what I now know, how I'm intending to make it work you know, we may need to, based on what I know from the software vendors, if they're not working quickly enough, and it looks like we're going to have, you know, a couple of pay periods ahead of us where you're going to have to incur this cost but not be able to get the credit immediately, then I may figure out a manual way for us to do this for you, so that it happens as soon as humanly possible, because I totally appreciate where everyone is at. You know, my business, you know, you know, the last thing we can afford right now is an increased, you know, cost of doing business due to federal mandates. So again, that's how I'm intending for it to work, but I'm still waiting to figure out exactly when everything will be in place with the software vendors, and I'll have more news to share as soon as I know more. So next question, we have two TINs, two different companies under the same owner, both with Checkmate. Can we apply for two loans? So again, that one is one where I do believe you would be restricted in one Paycheck Protection Program loan. It does the question, there are some technical details involved in the question though, regarding those affiliation rules. That is theoretically conceivable that you could have two employers that might be owned by the same individual that are in no way, shape, or form affiliated in any way at all. But I do believe, you know, in one of the ways in which that might happen is if, you know, one or both companies had like 30 owners, you know, that might be a situation where having one person that owns both might not prevent both companies from getting out a payroll protection or paycheck protection program loan. I do know that even if you can only get one paycheck protection loan, you could get another SBA loan for one of the other companies though. So it isn't necessarily the case that it's you know, universally you know, applicable that only one loan per owner. But to my knowledge, only one loan per paycheck protection program loan per owner. I have not been made aware that that is any different than what I've said here. Okay, so next question is, do you include employees from the report that no longer work for you? So yes, when I did my numbers, the folks that were on my team last year that are no longer here, that worked during the months that were part of the analysis for 1/2019 to 3/31/2020, were included in my numbers, and they were included in my FTE count. Technically speaking, right now, Checkmate has 16 employees, and my FTE count that I reported, my number of jobs that I reported was 17, because, you know, that was what the FTE count was last year. So yes, by default right now, by submitting my loan application indicating 17 FTEs and only having 16 today, if I only have 16 come the end of 6/30/2020, I might not get whatever 16 divided by 17 is times my principal amount, that might not get forgiven, but I might hire somebody between now and then too. Okay, so then are the PPP applications open yet? Yes. Our bank SVP is currently not accepting applications. So James, you know, send me an email, and I'll forward your information over, or I'll forward you the contact info for my point of contact at Enterprise. Do keep in mind, you know, right now Enterprise is giving first priority to their existing banking customers, but I did talk to them yesterday. I mentioned to them that I have many customers that might need somebody, you know, to jump in and help them out. And they told me that they would be more than happy to speak with anyone. They also, Enterprise operates primarily out of the southern part of the state, and they may, based on where you're located and who they know, you know, the folks that I'm connected with over there have been banking in New Hampshire for decades. So they know many people at other banks, and they may recommend that you speak to one of their colleagues at another bank based on where you're located and whatnot. But in any case, James, do just send me a quick email to remind me. I will send you the contact info for Enterprise, and hopefully they'll be able to help you out there. Okay, so with the applicant owner section, the owner is a UK limited company. Do you know the best way to fill the section in? So the applicant owner section. Yeah, that's a good question. And I will, James, I will get back to you with an answer to that question. I'll look that up here shortly. For right now, I would leave the field blank temporarily, but I will have a response for you this afternoon. Let's see. So then I'm hearing conflicting information on the additional 600 unemployment payment. Will an unemployed employee receive the full 600, or is there a calculation? There is a calculation. I don't know exactly what the calculation is. I do believe there's a calculation because yeah, there has to be, because I cannot fathom that somebody who's unemployed, receiving an unemployment benefit that's a reflection of the 20-hour work week that they used to have, would actually get $600 additional a week. I suppose that it could be possible that everybody's going to get it, but I'm almost certain that there's a calculation. Because the language that I recall reading indicated that employees will be eligible to receive up to an additional $600 per week. But again, that one is kind of, I don't have a really solid answer for you on that. I'm pretty sure there's a calculation. I'm pretty sure most employees will not get a full additional $600 per week. But at the same time, I do not know what the calculation is. And that's also an interesting question. We're gonna get an answer to that question for you, Paula, and we'll get it up on our FAQs page too, so that others can take advantage of our answer for future reference. Okay, so then next one is, will these pay codes keep track of our employee time off for Family First, even though we do not qualify for the tax credits? So far, yeah, municipalities, definitely, I agree. I also, I think that, I don't understand why, 501c6s were omitted from the CARES Act, for instance. Again, this is what happens when we have, legislators who have no concept of what it takes to actually comply with the legislation, quickly, put these things together behind closed doors. The right way to write legislation is to involve industry experts, in the drafting of it to begin with, not lobbyists, industry experts. It is what it is, right? So yes, the pay codes will keep track of the employee time for the Families First leave, even though you don't qualify for the tax credits. The entire reason why there are mandatorily 3 new earnings codes is exactly so that the tax credits can be processed, properly. And so yes, all of that time will be tracked separately, both on the time category side and the earning code side, even though you don't get the tax credit. I know we're over time, guys. I'm going to keep going, so as long as you're able to stay online, great. So I understood that loan forgiveness will be determined by the lender. Yep. While the monies are coming from the federal government via the SBA, is the bank that processes the loan considered the lender? Yes. And the bank that is processing the loan is considered the lender, even though the loan is being funded by the federal government. The loan is being guaranteed by the federal government, and the bank is the lender. And yes, it will be, the paperwork will be collected by the lender. The lender will have to sign off on your adhering to the requirements in order to forgive the loan. And in the event that the loan is not forgiven, then you will be paying monthly payments to the lender at 1% interest for 2 years after 6 months. How are you calculating FTEs? Good question. I meant to explain this. The FTE calculation in this context follows the ACA, interestingly. So a full-time employee is a 30-hour employee. Anybody that works less than 30 hours a week is a fraction of a 30-hour employee. And I also, when I did my FTE calculation, what I did is for my folks that moved on last year, I took the total compensation that they earned divided by the total annual compensation they were entitled to determine the fraction of a full employee that they represented, since they were not on my payroll for the whole year. For what period does one report FTEs on the PPP app? So it's the same period that you use to calculate your average cost of payroll, average monthly cost of payroll. So again, assuming that you run your numbers for the payroll report for 4/1/2019 to 3/31/2020, then your FTE count should reflect the period that the payroll numbers reflect. If you, if your numbers are all a reflection of 2019 calendar year, then in essence, your FTE calculation should reflect, the calendar year 2019. You shouldn't make your FTE count different from the period of time that was used to calculate your average monthly cost of payroll, because these two figures are being used together in conjunction, ultimately to determine whether or not you're meeting the requirements for forgiveness. Just to confirm, the loan balance you stated the loan is to be used in full, by 6/30/2020. If you do not use loan funds by 6/30/2020, they are not forgivable. So basically, if you have anything left, from the loan, come 6/30/2020, then either be ready to pay an interest rate or maybe give everyone a bonus. So let's see. Once the PPP application is submitted, anytime how long you hear, it'll take to hear from the bank. My expectation is that there's going to be a period of time here where I'm hearing from the bank periodically to let me know that they're working on it, and that hopefully by early next week, maybe a couple of days into next week, I'll have a sense from the bank of approximately when they will get to it based on the number that they have gotten through so far and the number that they have left. We should be reviewing your application no later than the week after next or something like that. I am not anticipating this is not, there's no way that this is happening as quickly as the federal government is telling us that it will. Hopefully I'm being naive. Hopefully things will happen, more smoothly and quickly, but I don't think that it is wise for us to assume that anybody will have PPP loan money in your bank prior to probably, if I had to speculate, that the soonest, the week of April 20th. Yes, so everybody's going to get an email with a link to the webinar video, and also we're putting up all of our webinars up on our COVID-19 website, which everybody on this webinar will have a link to here as well. Yes, and I'm getting a little bit of sleep here, but it is stressful times, and thank you everybody for the comments. Okay, so 2 more questions here. I do have to leave the meeting, but I have questions about employee counts. Okay, I'll talk to Deborah offline. How do you handle seasonal employees for FTE calc? So for seasonal employers, there's language on the basically, where is the language? Where does it live? So basically, for seasonal employers, the time frame for determining your average payroll costs is, I want to say it's either like 2/15/2019 to 6/30/2019, or like 1/1/2020 to 2/29/2020, something like that. I will get you a good response to that question, because there is a very specific answer to the question. But basically what you do in that context is you run your numbers, your payroll figures, over that same span of time, whatever that duration is. And in your FTE calculation, you make it reflect that duration as well. It makes your FTE calculation a bit more complicated, because the thing you have to think about here is not just straight up FTEs, it's FTEs as these individuals represent for, when we look at the totality of a year. So again, I have a salaried person that only worked for 3 months last year. So I consider her to be 0.25 FTEs. When it came to, calculating my number, because you only worked for a quarter of the year. That said, Darlene, I will email you offline with more details on that, or perhaps I'll call you directly. And then there's a couple of items in the chat here, so I just want to look at that real quick, and then I will end our webinar. Okay. So, I'm not sure about we were instructed to include all our part-timers because they are most of our payroll. So here's my my take on this. The FTE concept is not discussed anywhere when it comes to the loan app itself. The FTE concept is only discussed in anything that I've looked at so far that is related to forgiveness, okay? Given that the only information that is being requested that might be tied to your, the number of employees is this number of jobs field on the PPP loan application, my assumption is that that is the number that is being used to determine come 6/30/2020 whether or not you are employing the same number of individuals as you did for the period of time that was used to determine how much loan you qualify for. So the it would then, if this is an FTE calculation, if they are going to require you to prove that you employ the same number of FTEs, as of 6/30/2020, as you employed during the period in time where your loan calculation, the principal amount calculation was based off of, I don't see how you can't count part-timers as fractional employees. Because again, all of the forgiveness rules talk about FTEs. That's all they talk about is FTEs. There's nothing at all in the forgiveness rules that simply refers to number of employed people. So that all said, I will try to find some additional guidance on that and offer out, via our COVID-19 website and e-blasts to you guys some additional guidance on the FTE count. Next item is confused about the 941 for every quarter, the W-3 wage transmittal and the PPP loan analysis report. Which any of all do we get from you and when? So we provide you with copies of your 941s. The W-3 wage transmittal is part of your year-end tax package that comes to you somewhere, usually in the first couple weeks of January. In the PPP loan analysis report, it's the report that we are actively pushing into everybody's accounts that will show you, how much, how much your annual payroll costs come out to that you can then use for your loan application. So yes, we provide all of the documents. If you do not right now have easy access to the copies of your 941s and a W-3 wage transmittal, if you email me separately, I will make sure that one of my team helps out and gets you the documents that you need. Again, email me at covid19@checkmatepayroll.com, and we'll make sure that you get those documents that you need. And yes, for every customer that's still online here, all of these documents are accessible through Checkmate, since we, file all of your tax forms and the PPP loan analysis report naturally, comes from us because we're introducing it to you to begin with. What if your employees are under 30 hours? Do you still qualify for forgiveness? Their hours are planned to be the same as prior to the crisis. Yes, and again, you just need to count the fraction of a person that they represent. So, you know, a 20-hour employee would be a 2/3 of an FTE. And a 10-hour employee would be 1/3. Combined together, they equal 1 FTE. And again, I do think that is the information that needs to be provided here, at least in one way, shape, or form. You know, I think that the number of jobs field on the application, it doesn't make sense that anybody here would care or require that you tell them, you know, literally speaking, the number of jobs that you employ individuals to fulfill. I mean, for all we know, you could have, you know, one job that requires 10 individuals to fill, and you could have 10 individuals that have, you know, 5 jobs each. You know, I think jobs here is just a poorly labeled page field, and actually is asking for information that will be used to determine forgiveness. But again, I will do more research on that so that I can provide a better, more solid answer to the question, because it's a very legitimate question, and it's certainly, you know, again, just the spirit of all of this. You know, if it were truly the case that all they cared about was if I employ the same number of humans, you know, I could have 100 employees that all work an hour a week. You know, as opposed to, you know, and so I could staff up, I could add a whole bunch of people on 6/30/2020 just to make sure that I'm compliant with and get my loan forgiven. By adding 100 individuals and then firing them all on July 1st, you know, just to get my loan forgiven. So again, I think that what they're looking for is, you know, evidence that you are employing people for the same number of work hours that were used during the period of time in which this payroll loan calculation used to determine how much the principal was going to be. I think that they're simply trying to compare, in essence, you know, that you are still paying people for a similar number of work hours or man hours, if you will. And therefore, I do think that we will ultimately find that the part-timers need to be counted as partial FTEs. I will dig into that more. I will get news to the group as soon as I have it. We will get it out on our FAQ's website as soon as we can. And do stay tuned, guys, because we will have a couple more webinars next week on all of this. So with all that said, I appreciate everybody being online. If you have a particular need for that PPP loan report, please send that email to covid19@checkmatepayroll.com, and we will make sure that you're on the short list to get that attention ASAP. Thank you again, everyone. I hope everyone has as good a weekend as you can, given the you know, turmoil going on around here. You know, keep your heads up, and hopefully, you know, we'll get through next week, and the week after that, you know, smooth sailing. We are here to help if you need any support from us. I definitely, you know, am interested in speaking with anybody that wants to talk with me directly. Do bear with me, though. I do have, you know, quite a few folks that I'm trying to get to, and everybody, you are welcome. For all of the information that we're providing. It's the least that we can do. Thanks, everybody. I'm going to end the recording now and end the webinar. Do stay tuned for more invites for more webinars and more updates in our email. Take care. Have a good